Continuing from the previous discussion about a licensee's obligation to disclose a buyer's ability to perform, we now expand on another core responsibility: the duty to disclose any item that may materially impact a party's consideration to be paid in a real estate transaction. In Arizona, this obligation includes, but is not limited to, disclosing all known material defects, liens, or encumbrances affecting the property. These disclosures are fundamental to maintaining fairness, transparency, and trust among all parties, ensuring that the final contract reflects full knowledge of the property's true condition and financial standing. The Arizona Department of Real Estate, ADRE, and the courts have consistently interpreted this duty through ARS Section 322153A3 and Commissioner's Rule R428110-1A, which require that licensees deal fairly with all parties to a transaction and disclose in writing any information that materially and adversely affects the consideration to be paid. A material item is any fact that would reasonably influence a party's decision to buy, sell, or lease the property. In practice, this means that if the information could affect the property's value or the amount a buyer is willing to pay, it must be disclosed. Material defects generally include physical or structural issues, such as roof leaks, foundation cracks, pest infestations, plumbing deficiencies, or environmental hazards like mold or asbestos. For example, if a licensee becomes aware of recurring flooding in the basement or a history of termite damage, that information directly affects the property's market value and must be disclosed to prospective buyers, even if repairs were previously made. The precedent, set in Hill v. Jones, 1986, remains one of Arizona's most cited cases for this principle. In that case, the court held that sellers and their agents have an affirmative duty to disclose known termite damage, establishing that failure to do so constitutes fraud and misrepresentation. Beyond physical defects, a licensee must also disclose any known liens or encumbrances that could impact ownership or consideration. A lien is a legal claim or charge on property as security for a debt or obligation. Common examples include mechanics liens, tax liens, child support liens, and judgment liens. An encumbrance, on the other hand, is any claim, restriction, or limitation on property rights that could affect its transferability or value, such as easements, deed restrictions, or unpaid assessments. For instance, if a property has an existing mechanics lien due to unpaid contractor work, the buyer must be informed before entering into the transaction. Even if the lien is being disputed, it remains a recorded encumbrance that could interfere with clear title at closing. A licensee who knows of such a lien and fails to disclose it may be held liable for misrepresentation and subject to discipline. Similarly, if the licensee learns that a property has a homeowners association (HOA) lien for unpaid dues or a pending special assessment, this too must be disclosed because it directly impacts the buyer's financial obligations and ultimate consideration. The Arizona Association of Realtors Standard Residential Resale Real Estate Purchase Contract includes several provisions related to title and encumbrances, requiring the seller to deliver marketable title free of all liens and defects, except those accepted by the buyer in writing. However, this contractual protection does not absolve the licensee of their independent duty to disclose. The licensee must review the preliminary title report, tax records, and any recorded instruments that may affect title, ensuring that clients understand all items disclosed therein. Consider a practical example. A buyer makes an offer on a home, and during the title review process, the escrow officer discovers an undisclosed IRS tax lien on the property. If the licensee was previously aware of this lien and failed to mention it, that omission would violate the duty of full disclosure. The presence of the lien could delay closing or even void the transaction, leading to financial harm for both buyer and seller. In such a scenario, ADRE could impose sanctions for failing to disclose material facts known to the licensee. This is why it is so important to contact the title/escrow company and go over the title report with them if you or your client has any questions. Another common situation involves encroachments and easements. Suppose an agent knows that a neighbor's fence or shed encroaches onto the property being sold, or that the utility company holds an easement limiting future construction on the lot. These facts must be disclosed before closing, as they may restrict the buyer's intended use of the property or alter its market value. Likewise, if a property is located within a floodplain or subject to restrictive covenants, those are material conditions affecting consideration and must be communicated clearly to the buyer, as they could have monetary implications that may hinder the buyer financially. Material items affecting consideration are not limited to physical or recorded conditions. Financial obligations or pending litigation involving the property must also be disclosed if known. For instance, if the property is part of an ongoing lawsuit concerning boundary disputes, construction defects, or HOA issues, the licensee must inform the buyer, as such information could materially affect their decision to proceed. The ADRE views non-disclosure of litigation or potential liabilities as a violation of both statutory and ethical obligations under R4-28-1101B. It is important to note that while licensees must disclose all known material facts, they are not required to conduct exhaustive investigations to discover unknown issues, according to Commissioner's Rule R4-28-1101H. And a licensee is expected to exercise reasonable skill and care in identifying material matters, but may rely on information provided by reliable third parties, such as title companies, inspectors, or appraisers. However, once the licensee has actual knowledge, or should have known based on observable evidence, they cannot ignore or fail to communicate that information. Review summary. Arizona law requires licensees to disclose any known items that materially impact a party's consideration, including physical defects, liens, and encumbrances. Under ARS Section 32-2153, A3, and R4-28-1101A. The duty to disclose applies to all parties and encompasses both the physical condition of the property and its legal and financial status. Court cases, such as Hill v. Jones, establish the principle that non-disclosure of material defects constitutes fraud, while ADRE regulations ensure that licensees uphold honesty and transparency in all transactions. Understanding how to identify and disclose these issues protects clients, prevents litigation, and reinforces the integrity of Arizona's real estate industry. Discussion: why must liens or encumbrances be disclosed to a buyer before closing? Answer: because they directly affect the buyer's ownership rights and financial obligations, making them material to the consideration paid. What case established the duty to disclose termite damage in Arizona real estate transactions? Answer: Hill v. Jones, 1986, established that failure to disclose known termite damage constitutes fraud and misrepresentation. If a licensee knows of a pending HOA special assessment, what must they do? Answer: they must disclose it immediately, as it directly impacts the financial terms and overall consideration of the transaction. Closing remarks. Disclosure of material defects, liens, and encumbrances represents the highest level of ethical and legal responsibility a real estate professional holds. These disclosures protect all parties and uphold the integrity of the profession by ensuring that property transfers occur with full transparency. By proactively identifying, verifying, and communicating material facts that affect consideration, a licensee safeguards clients from future disputes, maintains compliance with Arizona statutes, and reinforces public trust in real estate professionals.